became full, so I had to stop. So as I'll just continue that even the second test, that the defendant must establish that he was not negligent in seeking out the evidence in question, that part also the test gets satisfied, because these are very technical in nature and these are based on facts. So the judge, there was no way she could actually go ahead and say these two tests, the Steven Avery case, it does not satisfy them, because the evidence presented, as I had mentioned in the earlier video, it came in the hands of the defense lawyers after the conviction of Steven Avery, and of course they also established that they were not negligent in seeking out the evidence in question, because the primary people who were supposed to go ahead and disclose the evidence, they did not do it. That is the state police. But that is where I want to just point out, as my earlier video I said, you cannot apply the Denny test in a scenario where the state police is a party. It is a party. They are a party to the whole things, which is putting them in a conflict of interest with the whole proceedings. There is no way you can say that Calumet County and the Manitowic County, they were not hand in hand, or they were not conducting the investigation in coordination with each other. Because you have one of the most major incidents which happened in the Avery trial, the tracking of the key in Avery's trailer, that was done by a Manitowic County police personnel. So when that happens, automatically it opens the Pandora's box and you cannot separate both the parties. And when two state entities, right, they are conducting an investigation, they become one, because they become one the moment you are actually going ahead and using an evidence found on the scene of crime to go ahead and convict a person, and that has been actually found by another county sheriff, that is the Manitowic County sheriff. You cannot separate them both. Then what happens is both these state entities become one. And when one of those state entities actually has a motive to put Steven Avery away, when they are facing a potential $40 million lawsuit, the Denny test cannot be applied in totality, impartially. You can't do it. The Denny test fails, right? But what you can do is you can apply the Edmonds test, because the Edmonds test has a better mathematical or an arithmetical formulae which could be used in order to push forward a post-conviction motion. So we have talked about the first two tests. Now let's go for the third test. The third is the defendant must establish that the evidence is material to an issue in the case. And fourth and finally, the defendant must prove that the evidence offered is not merely cumulative to that already in the court record. The defendant further notes that only if these four requirements are met is the circuit court required to determine whether a reasonable probability exists that a different result would be reached in a new trial. Now try and understand this. This is very interesting. Now when you satisfy all these four tests, then only the circuit court can determine whether a reasonable probability exists that a different result would be reached in a new trial. Now what is the point here? The point here is, and this is something which you all can understand also, the point is, will the very fact that Sovinsky saw Bobby Daisy in the RAV4 with an old man go ahead and generate certain doubts in the minds of the jury who were sitting in the Steven Avery case to actually go ahead and produce a different verdict? That is the test and that is the requirement. Now, in this case, is this happening? Okay, in my opinion, it does. Why does it? Because the jury is led to believe that after Teresa Hallback disappeared, her RAV4 could not be tracked anywhere else till it was found in the Avery yard by a person from the search party which was searching for Teresa Hallback. There was no way it could be tracked or it could be found. And that was one of the most important evidences which played on the jury's mind, which went ahead and implicated Steven Avery. I'm talking about the narrative, right? Number two, another point which directly helped them to make this decision was the fact that Bobby Daisy, who is in fact a relative of Steven Avery, their star witness, he went ahead and pointed out that he saw Teresa Hallback walk to the trailer of Steven Avery, and he was the last person who happened to see her. Now suppose you go ahead and produce such an explosive evidence that it was actually Bobby Daisy who was in the RAV4 on a day which was before the day it was actually found from the Avery salvage yard by the search party, by one of the members of the search party. The jury will definitely reconsider their decision, and the last 2 points, they get satisfied and the motion is allowed. Now, why was it not allowed? Because I just explained to you what are the 4 tests of Edmund, what needs to be satisfied, and how you can actually go ahead and get the motion allowed. And the judge has actually gone ahead and admitted the first 2 tests as saying, fine, these are absolutely okay, we can apply them, and Steven Avery's case satisfies these 2 tests. Now, when it comes to the 3rd or the 4th test, what happened? Where did the decision go awry? Let me explain it to you. Now, before I proceed, I would just like to point out certain facts of the case. In his affidavit, Mr. Sowinsky states that in the early morning of November 5, 2005, he was delivering newspapers to the Avery salvage yard in the course of his employment. Prior to actually delivering the newspapers, Mr. Sowinsky states that he encountered Bobby Daisy and an older unidentified man pushing a dark blue RAV4 down Avery Road towards the junkyard. Mr. Sowinsky stated that the car did not have its lights on. It was early morning, you could see clearly it was a RAV4 blue in color. After delivering the newspapers to the Avery mailbox, Mr. Sowinsky states that he drove back towards the exit where Bobby, the older gentleman, and the car were still there. Mr. Sowinsky states that Bobby then stepped in front of his vehicle in an attempt to stop him from leaving the property. So basically what we are seeing that there's a person who's trying to hide his crime. He doesn't want that person to leave, so he comes in front of the car. He further stated that his headlights were shining directly on Mr. Daisy at this point. Look at how detailed this statement is. Mr. Sowinsky then states that he came within 5 feet of Bobby Daisy, who looked unhappy to see him on the side of the road and was forced to swerve into the ditch to avoid him. Think about this. He did not move away. Why did he stand in front of the car? So he had to swerve into the ditch to avoid him. Fearing for his safety, Mr. Sowinsky called out, "Paper boy, got to go," he said, and drove towards the exit. After learning that Mrs. Hallback's car was found on the property, Mr. Sowinsky states that he realized the importance of what he had seen and immediately contacted the Manitoba County Sheriff's Department to report the encounter. Mr. Sowinsky states that after viewing the television show Making of a Murderer, he contacted the Innocence Project in New York to report the incident again. Finally, in 2020, Mr. Sowinsky contacted the defendant's current counsel and the current affidavit was drafted. So it was well after the conviction of the Steven Avery. So as we have told you, the first requirement, it is satisfied, judge agrees. The second standard of the Edmonds test, it is satisfied, judge agrees. Now let's go for the third standard, and this is the most interesting part of the judgment, and this is in page 8, second paragraph, and I will tell you in totality what it states and how ridiculous this is, because the point is, lawyers make their living by talking about all these gibberish, and a common man or a layman, they cannot understand exactly what's happening behind the scenes, right? I want to make it very simple for you, okay? Little bit like, okay, this is law for the dummies, don't take me otherwise. It's just that so that you understand, because we have already talked about the 4 standards, right? The third standard of the Edmonds test requires that the defendant established that the new evidence offered is material to an issue in the defendant's case. This is what the judge is saying. The evidence submitted as being material to the defendant's motion goes to his theory that a third person committed the crime for which the defendant was convicted of. For evidence to be admitted to establish that a third party committed a crime rather than the accused, the evidence must meet the test set forth in Deni Supra. See how clever she is. What she did was, there are 4 tests for Edmund. The third test, when it comes to the satisfaction of the requirement of the third test of Edmund, she takes the help of the Deni test. Now what does the Deni test do? As I told you, the Deni test is more about how to say that whether this person will reasonably go ahead and he has the legitimate tendency to go ahead and commit the crime. And that is very difficult to prove when you have a state agency colluding a lot of things within the property and trying to prove that. Okay? So what she does is she takes 2 requirements from the Edmonds test. But when the third test of the Edmonds test is taken into account, rather than going into the heart of the third test, which in itself has certain valid principles, which I will point out, she shifts gears and goes into the Deni test. Now what she says is, for evidence to meet the Deni test, the evidence offered must show that there is a legitimate tendency that a third party committed the crime alleged. More specifically, the evidence must establish that the third party had the motive, the opportunity, and a direct connection to the commission of crime itself, which I talked in the beginning of part 1, which I felt in a certain way it is satisfied. But in order to prove it as per the Deni test, you need DNA evidence, you need blood evidence, you need a very, very tight evidentiary link based on which you can actually convict Bobby Daisy. But you can't do that. It is very difficult to prove that because you don't have that evidence in your hand. And how do you have it when the state agency itself has a motive to ensure that Steven Avery actually goes to jail? It serves their purpose well. They don't have to pay $40 million. They can do it with $40,000. Think about it, right? So this part of the decision is completely wrong, because what she does is, for the third and fourth requirement of the Edmonds test, she takes the help of Deni test, which is not applicable in this case. And Kathleen Zellner did not go ahead and state anything from the Deni test. And Deni test should be read, which I would request the higher courts to consider. The Deni test should be applied taking into account the fact that the state agency is also a player in these proceedings. It's very difficult to say that yes, they committed the crime, they killed Teresa Hallback, they planted all the evidence, but it is important to note that they had a motive to actually go ahead and put Steven Avery away rather than Bobby Daisy in this crime. So that is a supposition which should be taken into account in order to go ahead and understand the motive here in this case. So that's what I am trying to tell you all. Read the judgment carefully. The judge has used two cases to deny the motion. There are two cases, you can open it and see it. One is the Edmonds case and one is the Denny test. Denny test, in my opinion, is not applicable. Edmonds test is the one which is applicable, but she has not applied it properly. Now let me go ahead and tell you what are the third and the fourth standards of Edmonds test and how it actually gets satisfied in this case. So just give me a minute. I will just go ahead and get into the Edmonds test so that everybody understands what are the third and the fourth requirements on how it actually fits the Steven Avery case and how it is would help, right? Now because I will be citing certain opinions from the Edmonds case so that you understand that how it is actually going ahead and satisfying it. And it's very interesting to note that for the Edmonds case, the circuit court had actually erred, and the Supreme Court actually reviewed the role of the circuit court and in analyzing newly discovered evidence and how it should be discovered, how it should be applied. It is very sad to see that the circuit courts are not going beyond or not applying their mind in order to understand what exactly the Edmonds test entails. Okay. See. So the Supreme Court reviewed the role of circuit court in analyzing the newly discovered evidence. This I'm trying to explain what the third standard is. Okay. Okay. The Supreme Court concluded that the circuit court erred in denying McClellan's motion to withdraw his Alford plea based on its determination that the recantation was less credible than the original accusation. Now, this is very important. The court explained that the circuit court applied an erroneous legal standard, which has also happened in this case, in this decision from the Sheboygan judge's case, by weighing the credible evidence. Because, listen to it, I'm telling you verbatim what it means. Because the correct legal standard when applying the reasonable probability of a different outcome criteria is whether there is a reasonable probability that a jury looking at both the accusation and the recantation would have a reasonable doubt as to the defendant's guilt. So what does this mean? This means that this does not have to come from the judge's eyes. She needs to go ahead and perceive it in the eyes of the jury. The standard is, when you're applying it, the reasonable probability of a different outcome criteria. When there is reasonable probability that a jury looking at both the accusation and the recantation in this case would have a reasonable doubt as to the defendant's guilt. Now tell me something. When you're talking about the narrative which Kratz applied in this case, in this whole narrative which was used to actually convict Steven Avery, right? Where does Bobby Daisy coming with his partner, older partner in the car come in? Because if we have to believe that Steven Avery killed Teresa Hallback and burnt her, in a burn pit behind his house, we have to completely believe the narrative which Kratz has stated, right? Because he used that narrative to convict Steven Avery by convincing the jury that this is the narrative, and the narrative is very simple. She goes ahead and meets him, and then he takes him into the trailer somehow, tricks him or lures him into the trailer, and goes ahead and inflicts a lot of torture on her, and then invites his nephew to also participate in the crime with him, and later on they kill her and they go ahead and dispose her whole body full. Can you believe it? In the burn pit beside his house, and he has a Halloween bonfire without any kind of dissection, dismemberment, nothing, just burns her whole, right? And then along with Brendan Daisy, he cleans up the garage. Isn't this the story, right? Now where does this part come in, where Bobby Daisy with his old person is actually driving a RAV4 or on the morning of 5th, and this is witnessed by the newspaper guy. It just doesn't fit. Now if it doesn't fit, that means there is an error, there is a gap in his narrative, and he needs to explain this. Either they go ahead and go after Sovinsky and say that you are lying, this is an absolute wrong thing you are saying, this is not correct. But what purpose does it serve Sovinsky to come out so many years later and say these things? Is he getting anything out of it? I don't think so. Right? Babla, ekটু আস্তে করবে? Baba, ekটু আস্তে করো. So, if this doesn't fit the narrative, then it automatically goes ahead and raises reasonable doubt to Avery's guilt, and that guilt would have been thought twice. The jury would have interpreted it differently and come out with a different outcome. And this is the standard which Edmund's test applies. It is an excellent test, but the county judge, instead of following that principle, what she did very cleverly was, in the third or the fourth standard, when she realized that if she applies this standard properly, she will have to actually allow the motion of Kathleen Zellner, she switches gears and she applies the Denny test, which is a more difficult test to satisfy with respect to this motion when we have a state agency also as a party or a player in the proceedings, because they can dilute the evidence, they can manipulate the evidence, they can do a lot of things. A lot of people might say that's a conspiracy theory, but they can do it. And what is the most motive? A massive amount of money, over $40 million, which Steven Avery was asking for, right? How much did he settle for? $40,000. Peanuts. For an 18-year jail sentence which he was not supposed to serve. Babla, ekটু আস্তে করবে? Babla, ekটু আস্তে করো. Babla, ekটু আস্তে করো না. একটু আস্তে করো. So, what the Supreme Court basically stated was that if there is a reasonable probability that a jury looking at both the accusation and recantation would have a reasonable doubt as to the defendant's guilt, then the circuit court must grant a new trial. Must grant a new trial. So basically what they state was, basis this new evidence which came in, if there is a reasonable probability that a jury looking at this would have a reasonable doubt to the defendant's guilt, the circuit court had to grant a new trial, which was not done. One more thing, under McCallum, the court applied a wrong legal standard. I'm just talking about another aspect to it. After determining that both parties presented credible evidence, it was not the court's role to weigh the evidence. Remember, this is a wonderful decision, Edmund's test. Instead, once the circuit court found that Edmund's newly discovered medical evidence was credible, it was required to determine whether there was a reasonable probability that a jury hearing all the medical evidence would have a reasonable doubt as to Edmund's guilt. Now, I can actually substitute by saying newly discovered evidence because I'm using the Edmund's test for Avery's case. So here if I look at Avery's point, say instead once the circuit court found the newly discovered evidence from Sowiecki was credible, it was required to determine whether there was a reasonable probability that a jury hearing all the evidence from Sowiecki would have a reasonable doubt as to Edmund's guilt. So what was required at this point was the Sheboygan judge had to go ahead just with one evidentiary hearing, nothing else. And that was of Sowiecki, where the state advocates would have cross-examined him and Zellner would have also presented her version of the argument. And if the jury found that yes, his words were credible enough, then if that could actually go ahead and create a certain degree of doubt in their heads that no, Steven Avery is not to blame, then a new trial had to be given. So if at all they had to go ahead, a simple evidentiary hearing would have sufficed, and that would have determined how true this man is. Because I still believe a human being, when he gets up on the stand, and if he's lying, and if he's not a part of the justice system or juries, he's not a lawyer or anything or a judge, it's difficult to fake words, because defense or prosecution, they are very good. I would say the state prosecution also has some brilliant lawyers, that is without saying. If he is lying, if Sowiecki is lying, that would have been ascertained. But instead of that, they simply denied the motion by misapplying the standards of the Edmund's test. I'm sorry, I'm just reading a few things so that I can just tell you. Basically, what the later part of the judgment is that they do not want to weigh the evidence. You cannot say for certain when it comes to reasonable probability what kind of evidence would weigh higher than the other. So that's why the Supreme Court has said that there may be a rare cause where our confidence in the outcome of the trial is undermined, and yet there is only a 50-50 or lower chance that the evidence would probably create reasonable doubt in a jury. We conclude that it is not so in this case. Basically what they are saying is doubt can be generated even by 5% or 10%. You don't know how it is going to generate the doubt in that human being's mind, in that jury. But if you see a kind of an evidence which on the face of it is definitely going to spark questions in your mind, that is a clear dead giveaway that a new trial should be given to this human being or this person who's presenting this new evidence. And in this case, it is very, very clear that this would have been very critical to Steven Avery's trial if it was introduced pre-conviction when the trial was on. Think about it. Firstly, look at the circumstances surrounding the statement. Sobinsky's statement was, they tried to shroud it. They tried to keep it away, the state. Right? Secondly, if we actually had introduced this during the trial, if it was introduced, do you think Bobby Dacey's statement that he saw Steven Avery last with the victim, would that have been would that have been accepted by the jury as well as it would have been if they knew that yes, he was seen in the car in the morning by a third party witness who had no interest in this case? No. That is where the reasonable doubt occurs. That is where this judge has erred in applying the principles. She has identified the right case, but she has introduced the Denny case, which does not apply with this case, and gone ahead and completely destroyed this whole process. She has destroyed it because we could have had a quicker trial right now. Whereas Zellner has to go to the appeals court, convince them about this principle, and then get a new trial again, which I hope she does. I believe you've got better judges in the appeals court, and I believe that if it does go to the Supreme Court somehow, they will see the reason behind all of this. Okay, so I hope you have all understood how the Sheboygan judge has erred in her decision. It's not a thorough decision. It is a very, very strange decision wherein you use the principles of one case in half. You know, there are 4 principles of the Edmonds test, so she uses just 2 principles from there, and the last 2, which are the most important standards, she just completely throws it out the window and introduces the Denny test, which is more difficult to prove in this circumstance, especially when you have a state player. And you have to acknowledge that there is a state player here because of just 2 facts. As I told you, let us not confuse ourselves. Just 2 facts. One is they were facing a lawsuit which was in millions of dollars, and if they could put Steven Avery away, even if he was a convicted murderer or anything, they would still have to pay Steven Avery. So what they could do through this, they could get some sort of traction, some sort of leverage, and that amount was brought down to a paltry $40,000 because Steven Avery needed to afford lawyers, and he did not have any money with him. Motive. And secondly, the act or the action. The action is, of course, the fact that the Manitoba County deputies, they were on the scene of the crime. It was through their engineerings that the Manitoba County coroner was not allowed in the crime scene. Look at it. It's a very interesting thing. It was disputed that the Manitoba County coroner, if she was supposed to be on the ground, there would be a conflict of interest. Whereas she was not involved in Steven Avery's past conviction. But the Manitoba County deputies who were involved in Steven Avery's past conviction and have done a lot of things which is borderline complete negligence in going ahead and putting him in jail and keeping him there despite evidence being given to them, those people were there in the crime scene. So essentially what happens is, the moment this happens, the supposition which enters is the Calumet County deputies, they are in the scene of the crime and they are doing two things. They are looking at the scene of crime for evidence. They are trying to gather the evidence. What is their second job? They are watching. They are watching Manitowoc County deputies to see that they don't do any mischief. So they have two tasks with them. Now, based on this, what is happening is the Manitowoc County deputy is actually finding the most crucial piece of evidence, and that is the key in Steven Avery's trailer. Now, when this happens is, you look at all the circumstantial evidence which you are using, mind you, to convict Steven Avery, right? Which you are again using to build the case based on the evidence which is being planted there, I would say, allegedly by certain parties who have a very good reason to do so. Now, in that case, the whole thing becomes colluded. The whole investigative process becomes colluded. It becomes diluted and wrecked. In that scenario, applying the Denny test is completely ridiculous, because application of the Denny test also gets violated and diluted, because the moment you introduce the state as a player, they can do anything. They can plant the evidence for Steven Avery. They can also go ahead and be in cahoots with the real murderer to frame Steven Avery so that they can actually get away with a lesser settlement amount. I hope you all have understood exactly what I'm trying to get at. I'm not going into all the things which are existing within this case, but I'm just going ahead and applying certain legal principles and showing, even if you apply these legal principles properly, Steven Avery should get a retrial, and in my opinion, he should be set free. I will be presenting another video soon, and it will be a very simple video regarding a very simple thing. And I will, because always I feel when a person is convicted, you should reconstruct the crime saying, okay, fine, Steven Avery is guilty. Now they are saying he has gone ahead and committed the crime. Now you need to look into the whole reconstruction of events and try to find out if at all there is any kind of an absurd, ridiculous thing which he has done which does not fit in. And that is exactly what I will be doing, to show you that if we go by Kratz theory or Kratz narrative of how Steven Avery committed the crime, it just can't happen. Even if Steven Avery has actually committed the crime, the narrative has to be different. It cannot be Kratz, because it's like a Tom and Jerry narrative. That's the best I can tell you. It's like a cartoon theory or a narrative and a reconstruction. A lot of things missing in between which need to be pointed out and highlighted. And I will be doing that in the next video. I'll be doing everything slowly and steadily so that all of you understand exactly what's happening. Thank you all. Power to Steven Avery, and may he be set free as soon as possible. Power to Kathleen Zellner, her persistence, her perseverance, and I was so happy to see that she's happy, because she knows that she can go ahead and file it in the appeals court, and she will stand a better chance, because you get better judges there who understand the case laws, who understand how to apply these principles, rather than just being pawns in the process. It is very, very unfortunate what is happening and what keeps on happening. It is not only a miscarriage of justice, it is a complete distortion of justice, what is happening in this